Welcome, everyone. The timer has gone off. We are officially at just over 8 o'clock. Welcome, everyone, to this presentation of Business as Usual. Our topic today is limited license legal technicians, the Supreme Court's recent mandate, and the recommendation of the committees. We're going to be talking all things, including what's recently happened in Washington. I'm very eager to talk about that. First, though, let me just pitch out to our sponsor of our program, Olson Thielen. They assist legal firms with tax, audit, and advisory services. They invite you to join the weekly online discussion about COVID resources and financial relief. More at otcpas.com, Q&A over coffee, which I believe is this link right here. They have a Q&A that follows this event, actually, every Wednesday morning. We thank Olson Thielen for their support. I also thank my guests for joining us. This is one of the most controversial topics at the Bar Association. I was at the assembly meeting when Landon spoke up. I remember Landon speaking up and having a voice in this conversation. Steve and Susan also were present. What was it, in 2017 now? It was a couple of years ago when the first recommendation of the committee was made.
I'm normally a very quiet and reserved individual. I don't tend to speak up on it.
Yeah.
Landon is our co-host. I think everyone knows Landon by now, but Susan, why don't you tell us a little bit about who you are and what your participation has been in the LLT space?
Sure. Susan Mundahl. I've been practicing law 31 years. In 9 years, I've had my own office, and I do exclusively family law. And so this was really important to me since this is the area that they're talking about. And last December, I was a part of the focus group, the day and a half focus group. And ironically, to talk about this subject, and we helped develop a plan for them to consider, which I understood from the last time Judge Thiessen talked, Justice Thiessen, that they didn't take any of the findings from that day and a half. But anyway, so I have done a lot of thinking about this and thinking about, maybe including that as a part of my practice is these, these legal prayer professionals and such. So that's my in on this.
Thank you, Susan. It's an interesting, I do want to get back around to the business opportunities, which I think is sometimes an overlooked piece of this conversation. Steve, why don't you tell us a little bit about who you are and your participation?
Sure. So I'm the Public Service Director here at the State Bar Association, and have been here at the bar for over 10 years now. And then in my work here, most people know me through the work that I do supporting pro bono. That is part of the work that I do. I help recruit and get trained and connect people to and develop programs for pro bono lawyers. Recognize help get the recognitions for our pro bono lawyers out there. So shout out to our North Star lawyers that were announced this week, last week, where you should be seeing it in your inserts in the Bench and Bar magazine, the names of the 884 North Star lawyers. That process and the development of that recognition I was involved with. I also am one of the two professional staff with my colleague Sherry Knuth, who's the Access to Justice Director for our Access to Justice Committee, and I also do work with several other bar committees at the MSBA and RCBA as well, now that we are staffing all of our work jointly here at the State Bar Office. I also, at the time that you were, Mike, were talking about the recommendations that were brought to the Assembly, I was the professional staff to the Alternative Legal Models Task Force. So I worked with the members who were putting together the recommendations to the bar. That was an interesting process. We did a lot of background work, both in terms of research. The committee members also, with the task force co-chairs, were involved with me in going out around the state to do some listening sessions before we presented the recommendations. And actually, the model that the models that the committee the task force brought forward included something like the triple LTs that Washington had adopted and we learned a lot about the Washington process, but also one that was used for quite a while in British Columbia, which is sort of an enhanced paralegal program, which is what actually the Supreme Court picked up on in last year when they created their paraprofessionals implementation group. So the paraprofessionals program that they're proposing is sort of modeled in part on the work that British Columbia did and on the recommendations that this task force had put together when they were in their discernment at the beginning of their work last year. I did get a chance to kind of give them some background and some context. And Judge Rodenberg, who was one of the co-chairs of the paraprofessionals working group, was on the task force that I worked on and was involved with the discussions and the deliberations. Ken White and Susan Weens, who are MSBA members, Ken practices in Mankato and Susan here in the Metro, were the co-chairs. So there was a lot of work that was done to really think through what we could present to the association. The recommendations weren't approved by the Assembly, but the Chief Justice was watching, so she decided with her colleagues to move it forward on their own. And after all, they're the ones who have the power to implement any kind of regulatory structure on this, so it's sort of in their ballpark ultimately anyway. But I think it'll be interesting to chat a little bit about some of the issues that people raised in that process, and I think are in people's minds when they think about what this paraprofessional pilot will look like and the different ways that they are talking about presenting this, to do some background and see if this will work.
My understanding is also that the process was similar in Washington as it is here, so similar path, if I'm understanding it correctly. The Bar Association in Washington also did not support the idea, but was overruled by the Supreme Court. I want to just ask both of you about need. Susan is practicing in family law, so her business is something that's likely to be impacted by this. Steve, you do pro bono work. I assume that you feel that almost every attorney should be able to commit to their 50 hours. If every attorney in Minnesota did, I'll start with Steve. If every attorney in Minnesota did 100 hours of pro bono work, doubled the recommendation, do we meet the need that's available, or the need that's out there for legal work?
Well, I would love as many people to do pro bono work as can possibly do it. That's my job, one aspect of my job. And certainly the need is huge. The system, the legal aid system, our organizations that operate our legal aid programs would need a lot of resources to be able to oversee and coordinate a program that encompassed everybody doing pro bono. I want to be really clear that that's not something that anybody is actually wanted from the legal aid community. There's never been a push for mandatory pro bono. And I say this because we just went through a discussion around pro bono reporting, and the Bar Assembly adopted the report of the Access to Justice Committee to petition the court when it is pending on pro bono reporting. And it really, I think the question is, we have a huge need gap. Only approximately 30 to 40% of our clients who are qualified by the legal aid programs to receive services can get services through the program, and that includes services with a pro bono lawyer. So we know that there's a huge need that is not being met. We know from the discussions that the Judge Rosenberg presented to the MSBA Assembly with the Chief Justice back a year and some ago, the documentation of the number of pro se litigants that we have coming in a variety of different, very important proceedings to people. I mean, family is certainly one of them, and landlord, tenant, and creditor, and other places. There are efforts to put together, and there's the program here in Hennepin County around housing court and matching them with someone to assist them in housing court. And that's something that MMLA and VLN and our pro bono communities doing in Hennepin County. And there's certainly the desire to see more of that in other parts of the state. But, from an implementation perspective, pro bono isn't free for the support and oversight that we need to provide to attorneys. So as attorneys want resources, they want to have someone they can check in with. Not everybody's trained to do all this work, does not do it as part of their regular area of practice. So there's a lot of ramp up that would be needed, but the need is there. So for attorneys who are in the place and space in their professional lives to do it, this is an opportunity. It's certainly, we know in our Rule 6.1 that that's something that we are asked to do as licensed lawyers in the state. And but the scope of the need and the way that we can respond to that, I think that's something that, this discussion around paraprofessionals is interesting, because as we talked to people about how they use paraprofessionals, many folks acknowledged, and not only the legal aid programs, but private practitioners, that their paralegals handle a lot of the kinds of work that can be done up until a point where there may be somebody in a courtroom proceeding, and in fact are more knowledgeable than junior lawyers coming out of law school about how those proceedings work. So what do you do in terms of leveraging that skill and that knowledge and the oversight that you want to provide to be able to help people to do that without getting into the area of committing unauthorized practice of law?
Susan, you were raising your hand. Go ahead.
Steve, here's a really interesting thing that's coming out of this whole COVID is the fact that the courts are moving now to doing more, virtual.
Mm-hmm.
And I honestly think that is the answer. And I've been involved in a couple groups that, were groups that talked with various judges about this. And the thing is that, I could do a lot more pro bono or, lower rates. It's simply a lower rate if my pretrial or if my ICMC is by phone, or actually I prefer the virtual so that you can see everyone. And I've done both of those. And and I see Tim's comment that it's unbundled services and sliding fee. And in the, in our focus group last December, our point was, this is not serving low income. This whole program is supposed to be designed for those above the low income level where they can pay something. They just don't want to pay full attorney dollars. And they did point out that in talking about who's unrepresented, that they're using figures from the start of divorces and actions. And yes, one side may be unrepresented, but after they've been served, they generally get counsel. And I do think that, those of us, I think we lawyers can answer the question to it. And that's my concern, is that I'm seeing that if the courts would do more about going to this virtual and have these hearings that they're talking about sending these LLLTs to, if in fact we can just simply appear that way. So now, an ICMC, it was 15 minutes instead of the 2 hours it took me to have to drive down, pay $20 and, get back, that I would have to charge my client. So so I think the court's in a unique position. Yay, let's talk about using lawyers now and going virtual and them doing the work. Because the other big thing that was raised, in terms of making this marketable to attorneys, like the question was, whose license is on the line? So if they have to be under the supervision of an attorney, now, is there going to be special licensing that's going to be done for these LLLTs? And there's no answer to that question. So if I'm going to have some of these folks, these paraprofessionals working for me, I'm envisioning that I could once a week meet with them. We do cases and we go through it and then we send them off to do it. But it is still going to be my malpractice insurance. And then the other is just simply, is it cost effective for us? Because it has to be something that's going to bring us money. Otherwise, you're right, it's just another form of doing pro bono work. And I'm sorry, but most of us family law attorneys end up, involuntarily having pro bono work, an awful lot, so those are my concerns with this program. And I heard Washington State at the time of the last December, they said only 20 people had availed themselves of that entire program, which means that's not the answer.
I do want to.
One of the things. Oh,
go ahead, Landon.
One of the things that I think we've talked about before is kind of, Tim, of course, talks about the unbundled services and sliding fee representation. We've talked a little bit about technology. And I think one of the problems to me is that a lot of times as we're talking about this, we say, this is the answer, this is the solution. And I think we need to acknowledge that in the access to justice world, there are so many different problems in so many different situations out there that we don't have one answer or one solution. I think we all know that. I'm just kind of, picking on terminology that we often use as attorneys to say this is the solution or this is the answer. I absolutely agree. I think we could increase or use what we've learned from this pandemic and try to streamline the courts. And I think some courts have gotten really good about the virtual hearings. Some have been dragged through this kicking and screaming. Some have refused to really make it work. I think that these virtual hearings could definitely save a lot of time and effort, money, and gas for everybody involved. I don't know that it is a solution, but I do think it's a step in the right direction. I also agree with Tim that unbundled services and sliding fee representation help as well. So I think we need to be aware of all the different blocks and bits that need to be used to try to address this. I had my reservations as I spoke at the assembly a couple of years ago regarding the 3LT. I don't see it as one of the blocks to address the access to justice gap. That's my personal view. I just don't see it. I don't see how we can expect to have an attorney essentially hire on an additional, well, in my situation where, for example, I'm a solo practitioner, hire on a paralegal that has gone through this program, thus because they have more education, they have more background, reasonably expects a higher pay to go through and do more work while placing my bar license on the line, meaning that I'm going to want to supervise that more, and essentially kind of go through this process and expect it's going to decrease the cost or somehow increase pro bono work. I don't see it, but if it works, that's fantastic. I would love it to work. I don't think it will.
I think, I'm sorry, go ahead, Mike. I want to add a couple of things, but go ahead.
You can skip right over this, but it feels like there is a basic assumption built into the proposal that you've all been alluding to, and that is that the industry, our profession, hasn't met a certain market problem. All right, it's a market issue where, because it assumes that there's a latent market for legal services, that there are those folks who maybe can't afford the standard rate that isn't being met by unbundled services or other discounted services. Seems like they're trying to solve a market problem that the industry itself hasn't been able to solve.
I think there are a few things that are sort of coming to the fore. One is having a portfolio of services available for people to think about that they can leverage based upon who they are, what their needs are, and their ability to pay. We have a legal aid system that exists for people who are at the lowest economic spectrum and in the case priority areas that our legal aid programs work on. And then you have people who exceed, and exceeding legal aid guidelines is not people who have a lot of money. These are folks who don't have a lot of money, but they can't receive free legal services through legal aid, and they have to go out into the market and find a way to pay. And that's where I think a lot of unbundled becomes really important. And one of the projects that I do administer is the Minnesota Unbundled Law Project, which is an opportunity to match people who are going to provide unbundled services with clients. We've been doing this since October of 2018, and we've had about 600 or more referrals through that to lawyers who are on the unbundled panel. And that obviously allows lawyers to decide how they want to implement unbundled or flat fees. And that's a response to modest income or more income clients who might not be able to pay full market rate. And then there are those who can pay full market rate. And we've got lawyer referral for that. I think the question to think about is, what is the business, what is the ability to implement this as part of a business model? The pilot aspect of this, I think, is the opportunity to test drive that. I think one way to do that is through a very regulated, separately licensed individual like a triple LT, which is the approach Washington State took. I think, one of the things that's become clear now that they've decided to sunset this program is it never took off in terms of the number of triple LTs that could be available to the public. There was this vision that there would be hundreds of these folks available in the community. It was not so. Part of the reason why it wasn't so is because if you look at the actual way that they implemented it, it's a mini law license, and therefore the training and licensing requirements and the amount of information that they needed to get through testing and that this person needed to get through training paralleled very closely the lawyer model. So the notion that we could create a less expensive pathway to creating service by having a separately licensed individual was pretty high. And so they took a very regulated structure and they sort of superimposed it on this. The paraprofessional one model, which we talked about in the task force, which the pilot project is being put forth by the court, is less regulated because, number one, there's no separate licensure. There's no additional licensure for the paraprofessional, in that it really depends on the lawyer being able to oversee and make sure that there's training for the individual. There are requirements, or there certainly are some things that the order sets forth that they want to see the paraprofessionals be able to do, but there isn't a separate structure that's been put in place. But the lawyer takes on more of the obligation, because the lawyer then has to be able to make the assessment: is this paraprofessional able to go in and do this? And their licensure and ultimately malpractice is going to be on the line as the oversight. But the advantage of that is that you don't then have the separate oversight structure. It makes it a lot easier for people to get to do this, because lawyers can then decide in their own practice. Now, is that feasible as a market opportunity? Is that a business model that will work? I think that is. I think that's something that's really important to think about, and I think the court's got to see in an evaluation of this whether this actually provides more service and provides this opportunity for lawyers to still be able to run a business doing this.
I think you've answered Joel's question in chat. I just want to respect the folks in chat. He was asking if paralegals have an obligation of candor with the tribunal. Not the paralegals, but in Washington, there is a set of rules of professional conduct for the triple LTs, which track pretty closely, I think, with the ABA standard rules.
Mm-hmm. And part of my understanding is that it was kind of the cost of oversight, cost of monitoring that was not a feasible business model. I will say I was looking through briefly to see if I could find that. I'm wondering if you could, Steve, I'm wondering if you could put that, or actually, I'm not sure whose screen I'm looking at.
This is Mike's screen. This is Mike's screen. Yeah.
Oh, sorry. Yeah. Okay. This is the dissent. The letter. The letter, interestingly, was also written by one of the dissenters, but it was just a couple of paragraphs long, saying that they were $1.4 million over budget. This is a much more interesting letter, I think, just because it's so strongly worded. I've had that up there for a little while, but yeah, it's which is a separate issue. The timing on this looks terrible, I have to say, from which is one of the points made in the letter from Justice Madsen, I believe is the name. Where the profession itself is being sort of docked for a lack of sense of urgency over issues like this, and without any. I do want to get to this. If anybody has any insight as to what happened here, there, according to Judge, it's Madsen, Justice Barbara Madsen, saying that there was no comments, no discussion. This is just sort of a black box decision without any input from the affected parties. Does anybody know what happened here, or are we still learning what's going on in Washington?
Well, my guess is there weren't enough people who were utilizing it. I mean, the thing is that, and we raised this at the meeting, is, people want to talk to the lawyer. They don't want to be put off to paralegals. I mean, that's, I utilize paralegals in my office to try and help people to save money. And they're like, no, they want to talk to me. And so now you're suggesting that, they don't want less than adequate service. And that's what I think, this LLT program is conceivably offering them. And I do think it's better that the court start looking at utilizing virtual meetings so that we don't have to go down for 5-minute hearings and such like that. And, Steve, do you offer the marketing? Because I actually have developed a DIY workshop, but the courts, because I'm a for-profit organization, will not advertise it. And it's like, okay, so, give us an opportunity to get it to the people who need it. I mean, I go through the whole thing. It's a 4-hour class. I charge $200 for it. And we can't get anyone to sign up because, we're putting it out on Facebook. There's a lot of interest, but people, and I've 31 years I've been practicing. I know the information. And so if I can't even get them to do it, I don't know that they're going to go to this new program, especially since, everyone wants a Tesla divorce. And maybe they can only afford, I don't know what cheap cars are anymore, So that's my 2 cents on it. I know I've got to get off at 8:30, but anyway, it's an interesting question.
And of course, in regards to the Zoom meetings, Joel also asked, and thanks for attending, Joel, also asks, how does a judge smell alcohol in the courtroom when all parties are Zooming? I think that's a little bit of humor injected, but I do think that there is, at least in the criminal field, there is a little bit of question in determining how involved the individuals are. I'm thinking when I go through and do a plea for an individual on, for a criminal offense, yes, I could submit a plea petition for somebody for a petty misdemeanor or gross. But when it comes down to a felony, we're expected to be in person. Now we're doing that by Zoom. There's also questions about the plea petitions that are submitted, but we're doing that by Zoom and hoping that covers everything that's needed and that the judge can make a decision while looking at all parties and make sure that they're aware of what's going on and they know what's happening. I think that there are some issues where Zoom meetings can be challenging, but I think a lot of those, for instance, I had an appearance at Ridgedale yesterday where I showed up to get another court date because we had just started the process. We got maybe 1 or 2 minutes of negotiation going, and it was time for me to leave because my 15 minutes in the courtroom were up and they needed to get the next set in. That could very easily have been done by Zoom. So I think there are situations where it works and there's situations where it doesn't, but we just need to be able to identify those and switch from one to the other.
I think there's the opportunity for the court to think about how they can use the technology in terms of the lawyer-only proceedings. I think where I get concerned just individually is where we know that clients have very uneven access to technology, and so their ability to appear also will be hampered by the fact that they may or may not be able to access that. Folks know that folks have smartphones, but the low-income people have a lot of different access to technology. Some of them do, some of them don't. Some of it's not reliable. So I do wonder about situations where people are going to need to go into proceedings where their ability to access it reliably will be at issue. But nevertheless, I think for the lawyer part of it, many people have said the same thing that both you and Susan, you Susan and Landon are saying, which is, we do a lot of work and waste a lot of time waiting around for things that could be done very easily. That's why some people send paralegals to do those things, because they don't want to be stuck at a scheduling, to get a scheduling order or to go to a scheduling conference or some really much less substantive and much more ministerial kind of process. That could be done in much more creative ways. And I think it's up to the court, and I think it's up to the bar advocating to the court that these kinds of ministerial-ish, or certainly, they're important, but they're not they're not going to be the adjudication of the actual issue. Proceedings and appearances could be done differently, and that's within their power to do that.
Sorry, I need to say goodbye, gentlemen, and thank you for including me as a part of this discussion. And if anyone
Thank you
has
very much.
questions, they can reach me, sjmundahl@mundahllaw.com. Have a good day, gentlemen.
Thanks, Susan.
And of course, Judge Cook, a regular member of our audience, thank you for chiming in. Yeah, there's concern about someone's intoxication, and I think more so their ability to reason and whether they're under the influence of anything while they're going through and doing this. And I think that's something that is far easier to determine. And he does point out that as an officer of the court, if I'm speaking with my client and I can tell he reeks of alcohol, there's no reason whatsoever that we should be going on the record. That needs to be dealt with, that needs to be taken care of. He can't make those decisions to go through and go on the record there. Another question that was popped up, and this is a little bit off topic, but since we're past 8:30, I want to bring it up. Nick Hansen brings up the question of, in context of George Floyd, do you think there will be a renewed push by states to re-examine the sorts of alternative legal models? I'm a little cynical on that. I don't think that there will be a renewed push, but that's me. I would love to see a renewed push. I think the challenge is going to be, and the challenge I think overall is tying the actions of the police officer to everything else that needs to happen. And I think that there's a good, strong push right now for a re-examination of how the police force is used in Minneapolis. But personally, I think that needs to, this is just me speaking. Personally, I think we need to figure out how that push can extend over to looking at the justice system as a whole, not just on the criminal side, but the civil side. How do we ensure services? How do we make sure everything is being done correctly? Not just in, having the police get out there to correctly address the situation, but once that's done, how do we make sure that they're going through the court system correctly if that's what needs to happen? How do we make sure they get the services they need? How do we do all of that? I would love to think we will get there. I would love to think that George Floyd's death was what will cause us to get there. I'm hoping that we get the momentum through this situation, this additional crisis that we're dealing with, to be able to get there and get more services out and readdress those services. But that's going to take a lot of willpower from not just the protesters, but it's going to take a lot of willpower from the members of the bar. So hopefully everybody's on board with that and ready to roll up our sleeves and get some work done. Again, my personal view.
Justice Madsen's point on that was in the last paragraph of her dissenting letter, which I pasted the link into the community. I also do need to handle my own ministerial work here for our call-in participants. I need to recite the CLE code for folks. It is 309-389. That's 309-389. Thanks everyone for joining us. Have we missed anything in chat or in Q&A?
We missed a fair amount in chat.
Let's get to it.
There's a lot in the chat, yeah.
Q&A has luckily been silent. I'll say I think the summary of a lot of what I've seen in the chat is trying to figure out how the limited license technicians are really going to address these problems and concerns and how they're going to interact with attorneys. And in part, it seems like the conversation is attorneys asking, what does the court want from us? What do they expect? How are we supposed to meet this need, even with the 3 LTs or whatever program we end up getting? And
I think it's important to remember that the program that the court's putting in place isn't the triple LT program that Washington State had. I think that I've noticed in these conversations that the conversation sort of we get analytically a little sloppy between triple LT and some of the other ways that they're talking about addressing the issue. What the court's proposing as the pilot, what they're trying to implement as a pilot, is not the triple LT program in Washington State. There are only actually a few states that have tried to even do anything similar to what Washington State did. And this isn't it. This is much more along the lines of the paraprofessional, enhanced paraprofessional program. So that this really does, and I noticed one of the people in the chat talked about this, this puts the attorneys as the ones who can make the decision about the ability of a paraprofessional, of a paralegal to appear. It puts the oversight and the responsibility for that decision-making as part of the attorney's practice management and oversight of their own practice and their clients' needs. Attorneys are doing this all the time. Attorneys make decisions about how to deploy their own attorneys if they hire junior attorneys, or their own paralegals if they use paralegals or legal assistants. This is not a new thing. And so I think what is different is there are some specifications the court's putting out there in terms of what they would like to see these paralegals to have in terms of the training and skills, but they're not going to regulate this through their own ability to regulate the profession. They're going to have the practitioners who are participating in this pilot do that. I think that's consistent with what I've heard other attorneys talk about. We want the ability to decide how we can use these resources to meet the needs of our clients. And this provides actually some additional flexibility to attorneys to do things that maybe folks would want a paraprofessional slash paralegal to do, but aren't comfortable doing because they're concerned that there's a UPL issue that I'm going to have to worry about because my paraprofessional paralegal is going to be doing something beyond what they should be doing. And this gives some cover for that. And it also provides an opportunity to see, is this workable? Is this something that actually increases service that an attorney who participates in this could actually make a living doing? The answer may be no. I actually don't know the answer to that question. That's why I think the court's decision to do this as a pilot makes sense. It's not going to be a global situation. It's a specific series of circumstances and locations where they want to do this. And I think, none of the folks on the paraprofessional pilot program implementation group we're going to be the ones doing this day to day. So they're going to have to rely on the professionals in our profession to be able to provide them with the data and information they need to be able to think, is this actually something that's workable? I don't think that the impetus, though, to try to think of different ways of meeting client needs at different levels of cost to increase service is one that we can argue with. I think lawyers do this naturally as part of their own innovation in the profession. But I think, going back to the question, Landon, that you were asking before about whether the George Floyd, all this discussions that we're now having around, race and racism and privilege and how do we deal with our community's needs in a thoughtful way is something we really have to think about, because we have to think about how people's basic needs and their ability to seek redress and or representation in the court system impacts their lives in very real and concrete ways. People who are housing insecure, who are job insecure, who are dealing with domestic issues at home or custody of their kids or their personal lives, their creditors coming at them, these are all stresses for folks to deal with. And we as lawyers should be concerned about how people are experiencing their ability to handle these issues in the judicial system, because we're the ones who are the licensed people to resolve these disputes with them, whether we're representing them or we're on the other side. And so I don't think we can get outside of the reality that if we set up a system and maintain a system that makes it very difficult for people to have confidence in it, so that they can see that they could actually get something from this process that they think is just, that they're going to bounce off into other ways that they experience our society and impact negatively their well-being, their sense of stress, their sense of faith in the community. So there's, I think, a lot at issue. It's not all going to be solved by a paraprofessional pilot program, But I think it's part of this bigger discussion about what is our judicial system and what is our legal system looking like. And we as lawyers, as people in the profession, should be concerned about how do we play a positive role in trying to make that happen in the ways that we think is just. And we could talk about all the implicit bias and questions around that. I'm leaving that to the side just for the moment and just talking mechanics.
And one of the questions that came up is, one of the questions was, of course, how does this impact Minnesota? And I think that's addressing how does what happened in Washington State address our program. At this point, I think it's way too early to tell. I think it may be an indicator or something that the courts will take into consideration when they ultimately decide to either keep the pilot program or not. But my understanding, based on the voice of the court when the Bar Association objected, is the pilot program is going forward.
I wonder if they considered the impact that that their decision would have on all these other states. I know, just working for the Bar Association, one very convincing argument to adopt a new program, initiative, advantage partner is all the other bar associations are doing it. Nobody wants to step in and be first. It's sometimes hard to lead in our profession. I wonder if they even considered what's happening in Minnesota, California, Arizona.
And one thing, of course, that Jerry has brought up is, I feel like I'm hearing words that I may have echoed a few years ago. Individuals, poor people, to put it bluntly, poor people deserve attorneys too. We shouldn't have quasi attorneys for people that don't have enough money and real attorneys for people that have enough money. I don't think that's actually addressing the access to justice, and I think that's just recoloring it. I think it's just saying, we've addressed the access to justice because you have somebody who's not a fully licensed attorney representing you, but they're able to. And I think part of that is, the argument is being made that, well, the paralegals or the program, the individuals in the program would be able to go to court for appearances and these quick little scheduling conferences and things like that. Well, one, why are we going to court if that's all that's happening? If you're going to court, if you're saying that we need to make that appearance, and the reason that we have to make that in-person appearance is simply to schedule another court date, then we shouldn't be having that appearance. But I think we all know that occasionally there are things that come up in those hearings and those appearances that are beyond selecting another date. It doesn't happen every time, but it happens a small percentage of times. And in those situations, all of a sudden you have somebody who is not a fully licensed attorney addressing something that you probably want a fully licensed attorney addressing. Otherwise, we should be looking at streamlining the system, not at having a quasi attorney filling in. So I think that's my take again.
Mike, it would be helpful, I think, perhaps I don't have the link right here at the top of my head, but I think if you go to the Legal Services Advisory Committee for the court, which is the court oversight and funding committee that funds legal aid programs. There's a project that was called Justice for All, which is a grant that Minnesota, through the judicial branch, as well as 6 other states, received from the National Center for State Courts. And the purpose of that was to do basically an assessment of our judicial system and the ability to meet the needs of clients across 16 different areas, one of which included whether or not there was some kind of access to unbundled or low bono services, but it included things like court simplification, court process, funding of legal services, the availability of lawyers for pro bono, as well as staff legal aid programs. And it's an interesting discussion to look at because they looked at forms, simplification, access to self-help resources, and they assessed, and it was a working group. I was part of it along with a number of other people across the judicial branch, legal aid sector, and practice, to look at the court system and think about different ways that we could provide services to people coming into the system. What I think is helpful about it as a resource is it really was trying to say that we want to get somebody in through the front door, which now we're using a website called lawhelpmn.org. And Law Help is a resource to anybody who wants to figure out what their legal issue is and how do I get legal services of any sort, whether you qualify for legal aid or not. But to provide a way to get people into the system, to have them assess what their needs are and their ability to get resources through legal aid. But if they don't, then to find other places for them to provide service. The goal is to be able to give people a place to go to get some kind of service for their legal issue. And I think it's important to think about having a range of ways of meeting that need. I think the question of need isn't the one that we're arguing over, because I think there is need there. The question of, do you have someone with you who is not a lawyer or not? If you have someone who's trained and experienced in something related to what your need is, if you are a low-income person or someone who doesn't have the ability to represent yourself, any assistance may actually be better than nothing at all, which is what I think a lot of people come into the assistance dealing with. And when you think of the issues around language and capacity that many clients deal with, you want to think about how we could provide something that this person can use and be able to receive service. So it takes a client perspective, I think, more than maybe we tend to think of as lawyers and practice at management of our own firms. It's looking at how does the client coming into the system experience the system and where can they find the things that they need. But the Justice for All assessment mentions that access to having someone, and that someone can be any number of different people. It could be a lawyer, it could be a licensed person, could be a paralegal, could be a lay person with specific knowledge in a specific court. Other states, for example, New York, are using lay navigators in some of their housing courts, not to provide legal advice, but to just provide procedural knowledge. Like, to tell the client, this is what's going to happen now, and this is what will happen next. And these are the forms you need to file, and this is what you want to think about when you're doing it. That kind of even basic work is really important to people who come in with no knowledge whatsoever. Now, are lawyers the only ones who can provide that? I don't think so. I do think we want to have lawyers doing the things that lawyers do well and have them be in the sweet spot, and I think we can have other people participating in that, because we want to make sure that they're able to do the work that's really the most valuable, where their skills, training, and experience are the most necessary. But there's also a range of need. And are other people able to participate in that and provide value to clients doing that, paid or unpaid, depending upon the circumstance? I think that's an open question.
I'm going to, for all the folks who are asking about these materials, there are too many for me to paste into the chat. And we should wrap as we're coming up on the top of the hour. But I just want to show where I'm going to share all of these materials. There is a folder in the Practice Law Library for the Business as Usual webcast. It's under the CLE materials and the recordings. You'll see that here. It says no credit because it's a recording. This live event does have credit. But what I'll do is share the video here, and the description of the document. I'll paste in all of the links to the resources. There's no text on this one, but I can add in all of the links and references to the materials we've chatted about today in the description of the document itself, so you'll have access to all of that stuff. Before we jump, though, I want to thank everyone for joining us today. I really, really appreciate this conversation, and I hope we can also continue this conversation. Landon, you want to tease our guest for next week?
Yeah. So, and before I do that, one last thing, we've had a lot of conversation about how are we going to address the access to justice. And one of the things that I keep wondering is how much information and how often do we reach out to those that are unrepresented to find out why they don't have attorneys? I know that we reach out and there's a response of, they cost too much, but how much do we talk to them about how many attorneys did you interview? What rates were you quoted? Things like that to try to understand and get as much information as possible to try to address this access to justice. And to be honest, I haven't heard of any of those surveys. Maybe they're being done in different practice areas, but I'm not hearing those questions being asked. And I'm concerned that we are viewing it as we're attorneys. We know this. We have the answers to these questions. We don't need to ask those people. And I think it's the aspect of those people and not asking, the individual that comes in and says, I don't have an attorney. I have to represent myself. We need to actually, if we're not doing it, we need to be asking, why don't you have an attorney? And not in an accusatory way, but in a help walk us through, how many people did you interview? Where did you search? Did you know that you might qualify for nonprofit programs and things like that? If it's being done, that's fantastic. I'd love to hear about it. If it's not being done, I'd love to hear it's being done.
Well, I think I think that is Michelle Stotts's project, right? They are continuing to do that research.
Yeah.
I know the American Bar Foundation has also done, and Steve, this is your area. I think you probably have a better idea of when that research is or where that's taking place.
Go
ahead.
Go ahead, Landon. No, what were you going to say, Landon?
I was going to throw out the plug for next week. We have Larry McDonough, who is going to be coming in talking about landlord, tenant, and housing and evictions and all the stuff that is the giant gray tsunami that is looming over us as soon as kind of the stay on evictions happens, which is coming up pretty quick. How we're looking at that happening, what business is going to go on for those that. If there's anybody out there that is not aware of all the amazing work that Larry McDonough has done in regards to the landlord-tenant work and really helping out tenants, I'll be amazed, but he will be here to talk to you next week and talk about the work that he's done and what he sees happening.
Steve, your final thoughts?
I think the issue around kind of what is it that clients actually need and how do they experience the system, I think some of that work was done with Justice for All and some of the discussions that they had, and also some focus groups work that was done. It was actually, there's been some client focus group that's part of this, that was done as part of that project to get an understanding of how people experience the system. But I think the point that you're making, Landon, about how do people experience the system and what do they actually need when they come into it is something that I think that's an ongoing problem about how do we get feedback on a systemic level. It's not just a matter of your client's satisfaction with your services as an individual attorney. It's about how do people experience it. I think the court system is actually well situated to at least collect some information because they get the input of who's showing up as a plaintiff or defendant in a matter in their court, and could think about how to use that information in a productive way to find out what is people's experiences. Sometimes I think their focus is on how do you experience our court process, and not maybe the big enough question, which is how do you experience the process start to finish, whether or not it's in the court or not. And some of that work was part of Justice for All. I think was one effort, but it's certainly something that we could continue to see people doing for a long time.
Thank you guys so much. And thanks to Susan Mundahl for joining us. Look forward to seeing you next week. Great conversation. I'll make sure I get the recording and all the materials, and there are many, up into the practice law library. Thanks everyone for joining us today.
Thank you.
Thank you, everybody.
Thanks. All right.